the Speaker having done something that is so wrong, particularly in not giving a hearing to the affected MPs. And the court said they should not be deprived of representing their constituents between now and when, Parliament ends its work. They should not be deprived.
Okay, thank you very much. I had the occasion to review the ruling of the Supreme Court, and I was really surprised that the Supreme Court took very seriously the issue of breach of natural rights. I mean, the right of the persons affected to be heard in their defense. Something. First of all, there was nothing to defend, in the sense that they had committed acts which, in the public domain, were tantamount, to a breach of Article 97. In other words, their conduct brought them squarely within Article 97. And the Speaker was merely invited, by the Honorable Atuforsen, okay, to take account of these developments, all right, and to say whether and the extent to which they had breached Article 97, or they could be brought within Article 97. Because in the view of the Honorable Majority Leader, okay, there had been the occurrence of a vacancy. And that is what he brought to the attention of the Speaker. So Mr. Speaker invited comments from the House. And after the commentary by, the members, including members from
Abusuya mo bibia kwa ba mfambra kwa Magenti TV so abusuya ba ensema hodwa aba begu montene so a ne nyina nyankopon ya adoma about work esi a chese da Ghana fo nyina dem. In fact, for the past years no with him say Ghana ya to ababi bre na we na ya about to chese. In fact, mo dene for the previous years no ndi ultimate national predator say anya the NPP be win, NDC be win, but system no kase no who is going to win no na chese akwa ya asem kase aba beto montene so we and then some who will be nebusia. My bobo biano, I'm the Somo, or Magenti TV YouTube channel. So, Serbia, yen be who and some air cosono. Mempesem Casabet and Yanko, Ninko video and Fambra, or commenter or beat me a drop or comment session.
Please resume your seat. I'm very serious about that.
Mr. Speaker,
please resume your seat. Honorable member, your
well, this is NPP. The founders of our tradition use the courts to do full right. And true to it, we are Democrats. We don't believe in violence. We don't believe in mischief and unnecessary political chaos. We came to court believing that the court will do right. And indeed, the court has just done that. The rights of those MPs have been reinforced, as well as the rights of those constituents who elected them. I will leave the Ghanaian public to peruse the full ruling of the court, and then the discussions can continue. But let me thank my colleagues in leadership, especially the hardworking Majority Chief Whip, for all the support and his industry. I thank senior members of Parliament, Uncle Joe Gatti, Honorable Kennedy Japan, not the least, Uncle Katie Hammond.
This is the Speaker's information to the House. So how do you say such an information?
But the Speaker was called to rule on a concern the Minority Leader had brought. Isn't that the case?
Are you the one calling it a ruling? Are you? the one calling it a ruling.
But what is it?
The person who spoke, hold on, the person who spoke to the House says, this is the information I have for you. So if you are labeling it as a ruling, I don't know how that can be so labeled. He says this is the information I have, that these 4 members of parliament have by their conduct done A, B, C, D. The speaker has given information to the House. Then somebody goes to the court and says that this amounts to a certain order, and therefore that order should be stayed. How is this to be stayed? With all due respect to the court.
This current Supreme Court is too predictable. And yesterday, I emphasized the point that the NPP may rush to court to get a verdict, with which they can dance around the present Supreme Court and back to Parliament. That's exactly what. But be that as it may, I am going to urge the general citizenry to just be respectful. Having said that, I'll add that I'm not surprised, because if you look at the composition of the Supreme Court that sat on the case today, they were all appointed by the current government. And I spoke against it. It was as if they were packing the court for instances that have happened today.
Why? Are you saying they've done?
Right. So you heard the Speaker of Parliament, Alban Bagbin. You heard Afenyo Marking. The two of them had a little banter there because he's alleged to have filed a suit. He had filed a suit, and he's alleged to have brought the suit in Parliament with the bailiffs. And the Speaker said he threw it at the people. And he tried to speak back at the Speaker to say, I didn't throw it. And the Speaker said, you are not listening. I didn't say you didn't throw it. At that moment when they were having the argument, I did a quick review, and I heard the Speaker say, you threw it. So Afenyo was right about that at that point. Except I'm asking, how do you serve a process whilst the Parliament is sitting in the light of Article 117 and 8? Well, let's see how all of that pans out. Then Roxanne and my colleague also here, what does that change really? Okay, so let's begin right here from the studio. And the Supreme Court, by what it has done, clearly points to the Speaker having done something that is so wrong, particularly in not giving a hearing to the affected MPs. And the court said they should not be deprived of representing their constituents between now and when, Parliament ends its work. They should not be deprived.
Okay, thank you very much. I had the occasion to review the ruling of the Supreme Court, and I was really surprised that the Supreme Court took very seriously the issue of breach of natural rights. I mean, the right of the persons affected to be heard in their defense. Something. First of all, there was nothing to defend, in the sense that they had committed acts which, in the public domain, were tantamount, to a breach of Article 97. In other words, their conduct brought them squarely within Article 97. And the Speaker was merely invited, by the Honorable Atuforsen, okay, to take account of these developments, all right, and to say whether and the extent to which they had breached Article 97, or they could be brought within Article 97. Because in the view of the Honorable Majority Leader, okay, there had been the occurrence of a vacancy. And that is what he brought to the attention of the Speaker. So Mr. Speaker invited comments from the House. And after the commentary by, the members, including members from the NPP side of the House, Mr. Speaker then decided to respond to the comments or to respond to the statement by the Honorable Atufosin. And it was his response that formed the basis of the so-called suit. Okay, but let's go back to the history of this development. You will recall that I think it was on the 15th of October at a rally in Tamale that the Honorable Member for Tamale South, the Honorable Harun Edrusu, made the point that there may be, okay, vacancies in Parliament when we resume. And he was basically referring to these developments. So when we resumed, I think on the was it on the 18th? 15th. We resumed on the 15th. Okay, so when did he?
Yeah, so he made a comment, I think sometime on the 13th.
On the 13th, not on the on the 13th.
No, I think when we resumed, the comment was made on the same 15th.
No,
the Speaker said
making it outside of Parliament.
Outside of Parliament. Yeah. Okay, so let's even say, I mean, I got the date wrong, but he made these comments in Tamale regarding the occurrence of the vacancies. Then when we came back, we resumed in Parliament. You know, he brought a notice of petition. Now, a notice of petition in Parliament is a notice to Mr. Speaker about, the intention or an expression of intention to bring a petition before Mr. Speaker. When that notice was brought to the attention of leadership, then the Honorable Atufosin said, look, in the circumstances, I have prepared a statement on this matter, and I'm invoking Order 93 of the Standing Orders to be able to make this statement. When he made the statement, Samson, at that point, the Honorable Afenyo Makin intimated to the House and to Mr. Speaker that he had filed a suit. Okay,
on
that day, the 15th. The suit was against the Attorney General and then the Right Honorable Speaker. And that was a development that surprised a lot of us, especially we, the legal practitioners in the House, because prior to Parliament taking any action, Afenyo Makin had already rushed to the court to issue a writ accompanied by a statement of case, saying that he was inviting the court to interpret Article 97. Now, I have not seen the papers that he filed, so I will not be able to talk about the reliefs. But when I read the ruling, one of the things that surprised me was the fact that the court took very seriously the whole idea that these persons were not given a hearing in Parliament, okay? Because in terms of parliamentary procedure and practice, right, when debate is ensuing, when Mr. Speaker invites comments, the members who are affected are at liberty to rise on their feet and say something in their defense, okay? The fact that they were not there on that day is of no consequence. Otherwise, debate in Parliament will be halted interminably, except to say that, okay, Mr. Speaker should have specially invited them to come and then, say something in their defense. But what were they going to say in their defense? That they have not filed, in the case of the Formina MP and the second Deputy Speaker, that he has not filed to contest, on the ticket of the New Patriotic Party, when that is a public fact, okay, verifiable from the, the Electoral Commission. In the case of the independents from our side, okay, he has filed, and we have evidence that he has filed to contest as an independent in Amenfi Central. And it is the same for the rest of them. So what were they going to say in their defense that makes it so important, so significant, that you would say that the right to natural justice was breached, and in the circumstances, the Speaker, was wrong, okay? Secondly, something, I looked at...
of the Kokwe says, this ought to have been triggered by the affected political party and not just any member of Parliament.
There is no support for that proposition in law. If you look at 97 and the Constitution as a whole, there is no procedure except under Article 99. And I will come to 99, in the course of my submissions. Under 99, you can trigger an action in the High Court, okay, on certain grounds, which I will talk about later. So, but if you take 97 as it stands, there is no procedure, either, in the Constitution itself or in our standing orders regarding the presentation of a petition by the, and then the whole idea that it is the political party that is affected, that has locus standi to bring, or that has the capacity to bring a suit, okay, that I think that proposition has no legal legs to, to stand on. So when the matter was brought to the attention of Mr. Speaker, it was within his right to invite comments. He invited comments. We all made, our input, okay, especially the lawyers in the House, including the Honorable Joe Gatti. And then Mr. Speaker decided to respond. And it is that response which is now the subject matter, of the ruling. But I was going to say that, you see, the Supreme Court in its ruling, okay, in the haste to, make its, assert its authority, okay, the court grossly erred on two accounts.
Show us how.
Right? On two accounts. First of all, there was an application. The subject matter of the ruling was an application for stay of execution. Something you and I know, right, that there is no executable order or ruling. For a stay of execution, an application for a stay of execution to be well-founded. First of all, there has to be, a judgment, right, an executable judgment, and ancillary orders or orders pursuant to that judgment which are about to be executed.
The famous NDK case,
NDK,
according to the Supreme Court.
And if you go back to even 1963, Joseph and Jebele, brothers, and so on. All right. So,
what does it mean? Explain to my viewers.